Hello, everyone. Welcome, and thank you for joining our webinar, The Legal Terrain of Metaverse, NFT, and Blockchain Practical Considerations, presented in partnership between the Legal 500 and Yoon & Young, the leading Korean firm. My name is Alan Cohen. I'm a research editor at the Legal 500. And well, before I hand over the webinar to our panel, I'll give a brief introduction of today's topic. So as the title suggests, we'll be discussing the evolution of Metaverse, NFT, and blockchains, which has generated a dynamic interplay of IP, publicity rights, regulatory compliance, and content-related contractual disputes beyond national borders and across industries. This webinar will focus on the recent trends and their effects on the international arbitration sector. But first, let me introduce the panelists who will lead us through the presentation. Joining us is Myung-An Kim. Myung-An, do you want to say a quick hello so our audience can see who you are? Myung-An is a partner and senior foreign attorney at Yoon & Young, where she co-heads the firm's international arbitration and dispute resolution team, and is a member of the California Bar. She practices in the areas of international dispute resolution, shipping, commodities, aviation, insurance, and trade. Before joining Yoon & Young, she worked as a foreign attorney at Lee & Co. and as off-counsel at Holman & Williams' Singapore office. Myung-An has successfully represented a number of domestic and international entities in ICC, SIAC, DIS, LMAA, HKIAC, and KCAB arbitrations, including enforcement procedures. And in addition to her practice, she has worked as an adjunct professor of law at the Hankook University of Foreign Studies in Seoul. Also joining us is Stephanie Feisterer. Stephanie, do you want to say hi?
Yes, hello everybody from Zurich.
As a partner at Homberg, Stephanie specializes in international arbitration and litigation. She regularly acts as counsel and arbitrator in arbitration proceedings. She represents clients in complex state court litigations and in a broad range of matters, in particular in international and cross-border disputes. As a special focus, though, Stephanie represents entrepreneurs, foundations, and international families in contentious trusts, estates, and other matters. She's a member of the arbitration courts at the Swiss Arbitration Center, a member of the Swiss Commission of Arbitration and of the ADR Commission at the International Chamber of Commerce. And she's also a lecturer at the University of St. Gallen. Stephanie has been involved in more than 50 arbitration proceedings governed by the ICC, the Swiss, the LCRA, the UNCITRAL arbitration rules, and in ad hoc and ICSID arbitration proceedings. She's experienced in disputes arising inter alia, out of agency and distribution, joint ventures and share order agreements, M&A transactions, and international sales contracts. Finally, I must point out that Stephanie has been recognized as a future leader by Who's Who Legal and as a rising star by the Legal 500 in the field of arbitration, and that she is the author of a number of publications in the field of dispute resolution. Our third panelist is Stephen Lim. Stephen, do you want to say hi?
Good afternoon, good morning to everyone. It's obvious who I am because I'm the thorn amongst the roses on this panel.
Stephen is an arbitrator and a barrister, a member of the English and Singapore bars. He's over 80 appointments in international cases as presiding, sole co-arbitrator, and emergency arbitrator. He's a member of various arbitration centers, commissions, and offices, including the SIAC, HKIAC, ARAC, and Tingzhou Arbitration Commission, and the IDRC panels at the India office. He's also sat in ICC, SCMA, LMAA, and CITRAL arbitration rules and ad hoc cases. And finally, I should mention that he's been ranked and awarded in several, if not many, legal directories for his outstanding work. So I'll hand over to our panelists in a moment, but before that, I would like to let the audience know that this session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A function, which is at the bottom of the screen, and we will put them to the panel once the presentation is over. Okay, then Myungan, I'm handing this over to you now. Feel free to introduce the topic a bit further and just lead the conversation. Just get us on the way.
Thank you, Alan. It's a pleasure to be able to stand or sit shoulder to shoulder with such great members of the panel today. And I am grateful to the Legal 500 for co-hosting the event with Yoon and Yang. As helpfully indicated by Alan, today we'll be covering some of the evolving areas of technology and how that may impact the way in which we resolve our dispute, particularly via arbitration, as well as the content or the actual substance of the dispute that we handle as practitioners. Now, just by way of background, as of 2022, NFT sales are estimated to be in the region of about 14 billion US dollars. According to Morgan Stanley, Metaverse gaming and NFT tokens could represent a revenue opportunity for luxury goods markets and manufacturers in the region of about 56 billion US dollars by 2030. In October of last year, the Seoul city government of Korea announced its 5-year plan to create a fully accommodating virtual ecosystem for all areas of civil, cultural, educational, and tourism services. And so virtual tourist zones and metaverse centers where civic services and administrative services could be provided can be available by estimate by about 2023. And 3D tech companies, most of them are in the US, but interspersed around the world, they are actually enhancing the metaverse technologies, and they predict that a large proportion of the general populace will be in the metaverse zone or in the usage of metaverse technology, just as we're using smartphones right now, by about 2030. So this is against this backdrop that our panel is presenting today's topic. Just for your ease of reference, we'll first address the overview of general concepts, the key concepts and the status as of today, followed by the challenges and prospects in terms of international arbitration and dispute resolution. And then we'll conclude our presentation by providing some practical considerations and takeaways for our audience members. And then if we have time left, we'll obviously be happy to open the floor for the questions. But as Ellen indicated, we will welcome any questions in the interim if there are any urgent queries or suggestions as well. So let's jump in. So in terms of these technologies that we've just stipulated, Metaverse, we've been hearing a lot about Metaverse as well as NFTs and cryptocurrencies. What are we exactly talking about when we refer to these evolving terms? As you may be well aware, Metaverse is a virtual platform where users use their avatars, or what you call digital representations, in order to engage in activities with each other with their digitally created items or assets. It could blend physical biometrics and personal data in order to customize and enhance virtual reality for each person online. The technology continues to evolve, and it tends to provide virtual alternative to human interactions and economic transactions as well. So present examples, we may refer to some of the clips that may have been in the media, but just for the sake of reference, we had an opportunity to look at the artists who may have used Metaverse technology to avail their recording clips online. You may be well aware of BTS's recent release of their new song Dynamite via online game called Fortnite. There was a recent virtual hearing, which you may have been aware of in terms of international arbitration, where this entity called ArbTech was providing participants with the VR headsets in order to assist them to access his or her avatar to partake in the virtual arbitration session. And then Kluwer had an interesting article about the practical challenges and pros and cons pertaining to that particular session. And then digital representation of designer goods and accessories are being sold, actually, as of now, on mainly on Roblox. It's a virtual game platform with about 150 users as of today, and about $38 billion US valuation with virtual currency. And then NFTs are being linked to the digital crypto wallets, which is a program that allows you to transfer and store cryptocurrency, which can then be used on various platforms, forming your virtual currencies necessary for signing, or what we usually refer to as transacting online. So, you know, that does provide some snippet of where we are in terms of this metaverse technology. Now, in terms of NFTs, it, as you may be aware, it refers to a digital collectible that can be in various forms of art, contents, and items. And sellers, and they could be artists or manufacturers that we just referred to. The sellers can create or mint, quote unquote, the NFTs on blockchain based on marketplace platform. And the most known form of this marketplace is called OpenSea platform. And when this NFT is sold, the buyer actually receives the NFT in his or her digital wallet, and NFT can be transferred from one owner to the other using blockchain technology, which then creates a digital trail that verifies the transaction and encodes the ownership rights. So one must have cryptocurrency in order to purchase this NFT digital assets and create an account on the NFT marketplace that is then connected to the cryptocurrency wallet. And then we also refer to cryptocurrencies quite often these days. And cryptocurrency basically refers to an encrypted data string that represents a unit of currency online, and it's monitored and organized by peer-to-peer network called blockchain, which then functions as a secure platform or half-secure platform for transactions. And I will come back to the term half-secure and explain as to why I qualify that term as well. Now, I'll pause here and then defer to Stephanie to comment a little bit about metaverse in arbitration and the statistics.
Thank you very, very much, Myung-An. It's a pleasure to do this this panel with you and Stephen. As Myung-An said, metaverse is booming. Over the past few months, tech giants, clothing brands, and individuals have invested hundreds of millions of US dollars in the metaverse. And virtual real estate prices are also increasing massively. And I've tried to look at numbers, and it's always difficult to predict. And the number I have found is that the metaverse market is expected to rise up to around $700 billion US in the next couple of years. So if that is true, and even if it's not true, the metaverse will undoubtedly give rise to new and complex legal issues, and legal disputes are indeed already surfacing in the state courts where we can hear of them. We will hear more about some of these disputes later on. Now, a major source for contention as of now is the question on who owns rights in the metaverse and whether they include the right to mint or create a corresponding NFT. But there are also other disputes. For sure, there are claims by users against metaverse platforms. In fact, most metaverse platforms provide for an arbitration clause in their terms of service. By way of example, Decentraland which is one of the platforms for metaverse services. Their terms of use contain an arbitration clause providing for arbitration under the ICC rules. We can therefore safely say that international arbitration has already entered the new virtual marketplace. And as we will also hear later, it seems well placed to become the dispute resolution method of choice for user-to-platform metaverse disputes. Now, if we look at the ICC statistics, we can see that around 5% of their caseload relates to specialized technologies, as they call it. Hence, out of the roughly 1,000 cases the ICC has every year, around 50 would pertain to specialized technologies. How many of them relate to blockchain or metaverse as a technology is a little unclear. Now, there are also some specialized dispute resolution mechanism, and we will also hear more on them later on. And we can see there too, there is a certain amount of disputes already now. And we will hear more about Celeros, I believe, which is a blockchain service, dispute resolution service provider. And according to their website, they had around 1,200 cases submitted and judged by their jurors. So we can see that disputes in the metaverse have arrived to arbitration. Myung-An, thank you.
Thank you, Stephanie. So that's a really good segue for us to delve into the next item, which is the cryptocurrency and NFT related disputes in detail, perhaps some of the present or potential areas of relevant disputes and industries where the relevant disputes are or will likely to be on the rise. And so against that backdrop, the disputes might be twofold. It could be related to the form or the platform in which the content is provided, or it could alternatively related to the content or substance of this metaverse, NFTs, or cryptocurrency related transactions. One of the most obvious examples that we've seen pertains to the copyright law, and it gets a bit complicated in the sense that the copyright law tends to vary depending on the jurisdiction. And so jurisdictional differences in dealing with, say, by way of example, freedom of panorama, and some of us dealing with IP or relevant disputes may have been familiar with this concept pertaining to the freedom to take photos and video footages of the images or the buildings or artworks that are permanently in the public place. And in the United States, assembled artistic pieces or architectural exteriors in the public domain may be duplicated by photo or video footages, but there are certain restrictions applied to the artistic pieces. And it does raise potential then claims in metaverse world where the users might feel drawn to a certain exterior or artistic piece and try to incorporate that into that virtual reality. In Korea, there's a wider acceptance of the right to assembly and duplication, i.e. pertaining to this freedom of panorama, but it could be subject to further evolution depending on the law pertaining to the panoramic view and how that is incorporated in the metaverse and virtual world going forward. And then another type of claim or industry pertaining to these evolutionary technologies could be the way in which cryptocurrencies are dealt with and maintained and exchanged. We've recently seen a case, local case, where the cryptocurrency platform was subject to hackers. and the server basically was not able to maintain the security of the users' identities and some of the personal information, subsequent to which the Seoul District Court, facing the claim by the users of this platform, ordered the platform operator to reimburse the users by way of providing further Bitcoins or cryptocurrencies or just a cash refund to the members. And we took interest in the case given the fact that it does provide a certain standards or reasonable level of or standards of due care applied for this type of technology and platform operators in this day and age of cybersecurity and metaverse and cryptocurrency. The other obvious area of dispute or further questions may be in the regulatory climate. The Korean government in recent years, as recent as back in 2017, had announced that the digital coin offering called ICO and digital initial exchange offering IEO may not be entirely permissible, but without stipulating any strict sanctions in case of any breach. And then following that route, but slightly differing from that route, the new president-elect of Korea has recently announced that IEO will be permitted, and then followed by the ICO, which will open possibilities for further development in this arena. The Korean National Assembly Research Service, 국회 입법조사청 in Korea, in 2021 released its research report saying that Metaverse is similar to virtual game, but may also be different in the sense that it cannot be reset unless other members or users and or the service providers agree to reset the program itself, leaving some room for different interpretation and regulatory scheme for Metaverse as opposed to the standard game industry that had been in place. And in terms of NFTs, whether or not that qualifies as a virtual asset, period, or some type of security certifying the ownership of the virtual asset is also a key question that's percolating in the regulatory climate here, and we're keeping a very close eye on the development in order to guide our clients and assist them in the best way possible. And then finally, slightly more exciting area of dispute pertaining to this was Miramax versus Quentin Tarantino. This is a recent case that had been filed in the California federal court earlier this year. And the key dispute in question is whether the reservation of rights clause that had been in place in the contract that had been executed between Miramax Studio and the director of the movie Pulp Fiction, Quentin Tarantino, back in 1993, whether that would apply to restrict or expand the scope of rights that could be owned and utilized by either the studio or the director in utilizing NFT collection based on Pulp Fiction. And it largely depends on language of the reservation of rights clause in that particular contract. But it'll be interesting for us practitioners to see the scope of interpretation applied by the court in the context of copyright, the industry custom that might be applied in ruling against or for the claimants here, the Miramax. And in the context of this technology, how do you determine what type of factors do you consider in determining the intent, contemporaneous intent at the time the parties entered into the contract back in 1993 when Metaverse was not even in existence. I'll pause here now and we'll turn to Stephanie and Stephen to comment further on the regulatory environment or lack thereof in general, and we'll move on to the challenges and prospects of these technology issues in the context of international arbitration thereafter. May I turn to Stephen first?
Thank you very much, Myung-An. Thank you for having me as part of this webinar. Well, as far as regulation of the metaverse and NFTs and cryptocurrencies. In Singapore at the moment, as far as I'm aware, there is no regulation of the metaverse. And there's also, as far as I'm aware, there's no regulation of NFTs. There is some regulation of cryptocurrencies in the sense that any entity that deals in cryptocurrency needs to be licensed by the monetary authority in Singapore. So if you want to deal, if you're a current cryptocurrency exchange, etc., then you need to be licensed. But there is no cryptocurrency that is licensed for use as a currency in Singapore. And also cryptocurrency trading is discouraged by the Monetary Authority of Singapore. So it's pretty much a situation of watching the technology as it develops, and the regulation, I think, will follow as it's seen where regulation might be needed. But that's the situation in Singapore right now.
Thank you, Stephanie.
I'll continue with the situation in Switzerland. In Switzerland, we see, especially in the financial sector, we see a growing fintech and blockchain ecosystem, and hence for Switzerland as a business location, it's crucial to have the legal framework that enables these services here in Switzerland. Back in 2018, the Swiss Federal Council debated on whether Switzerland should adopt a blockchain law governing all the issues concerning blockchain, or whether it should simply adapt the existing legal requirements or legal provisions to blockchain applications or distributed ledger technologies. And the latter is in fact what has happened. And in the meantime, a federal law, an act on the adaptation of federal law to developments in distributed electronic register technologies, in short, the DLT Act, has entered into force last year. It mainly governs areas in the financial regulation areas, corporate law. So one of the aspects that DLT Act governs is it has introduced the concept of uncertificated register securities and allows corporations to issue shares in tokenized form. And then a second aspect that was introduced by this DLT Act is it introduced a new license category for financial market infrastructures. And these DLT trading venues, as they are called, they may offer services in the areas of trading, clearing, settlement, and custody of DLT-based assets. And the final change that was introduced was the DLT law introduced a new segregation regime that will allow the segregation of crypto assets for the benefit of creditors in the case of a bankruptcy. Now, if we look at the metaverse, there too, an NFT, there too, we see, as in Singapore, an absence of any legal rules that govern these new technologies.
Indeed, thank you. It does seem to provide certain running theme across the board in the sense that there aren't any specific legislation on point as of now, but it will be a mixture of diverse areas of the law that will have to address content and form-based disputes that might arise in these areas. Very helpful to know. Thank you. The next item on our agenda today was to kind of discuss, the challenges and prospects in this field. First question might be, for Stephanie, what, in your view, are some of the forward-looking prospects in general, particularly in dealing with arbitration in technology?
Thank you. I think some of the prospects have already become a reality due to the COVID-19 pandemic that has hit us. And if it had one benefit, I think it brought around a huge evolution in technology in international arbitration. Some of the arbitration rules already allowed for remote hearings or so, but there was, to my knowledge, no arbitration rules that would really allow for online arbitration or arbitration be held virtually. Now, what the arbitration institutions have done over the last 2 years, they have almost all of them have revised their rules in order to now or issued any protocols that now allow for the efficient use of technology in our international arbitration. So what we are now seeing is some sort of online arbitration. And now going to the prospects, I believe in the future we may see really pure online arbitrations, in the sense that, of course, hearings would be conducted through video conferences. But what we may also see is that the parties may simply be required to upload their submissions and documents to a platform, respond to questions from the arbitral tribunal through these platforms, and then the decision of the tribunal will also be rendered through a platform. The advantages are obvious: lower costs and greater flexibility. You could also imagine that the entire dispute resolution process as such is moved to the metaverse. In fact, as Myung-An has mentioned in the beginning, we have seen some examples of that. And indeed, the arbitration community is already questioning whether the parties should be allowed to use their digital identities, their avatars, to appear in an arbitration in the metaverse. And of course, it is an even more trickier question whether the arbitrator should be able to use their avatar to appear in an arbitration. Moreover, in the metaverse, where anonymous avatars from all around the world are interacting and transacting with each other, time, location, and identity are fluid perceptions. And so the legal concepts of residence or place of business or seat, which are at the core of private international law rules, become meaningless in this context. We can also think about more complex procedural issues that could arise. Indeed, tribunals normally apply, when they look at whether an arbitration clause has been validly concluded, they apply, in the absence of a choice of the parties, they apply the law of the seat of the arbitration. So what is then the seat of an arbitration conducted in the metaverse? And what is the applicable lex arbitri, the arbitration law, for such arbitrations? And then blockchain arbitration is another concept that we may see in the future. And indeed, there are already several models of blockchain arbitration that are being developed, such as CodeLegit and Celeros. And I believe Stephen will say a few words on these in the following. Stephen, please.
Thank you very much. Okay, let me pick up on what Stephanie's been introducing and talk about some of the different methods of dispute resolution that have arisen to deal with this new technology and this new universe. Some of these would be more familiar to those of us who are familiar with arbitration. It looks more like an arbitration as we're used to, but some of these are not, and they actually rethinking how justice can be effected in this new metaverse and in this new realm of technology. So staying with the more familiar for the moment, increasingly we have been seeing that there are arbitral institutions that are focusing on online dispute resolution. There are some, I believe in Hong Kong, there is an institution that basically deals with e-commerce, and it's primarily online. DLOS was an institution that was set up, again, primarily with the view of fostering online dispute resolution, but the actual structure and the procedure that we of these arbitrations are much more familiar to those of us who are dealing with arbitration, perhaps if I call it in the paper world. Then we see that this moves on to other realms. There was a set of blockchain arbitration rules that were developed by an entity known as Datarella with the assistance from an international law firm. These were primarily based on the ancestral arbitration rules. So this again then has some familiarity and structure with how we understand arbitration to be. But the rules allowed for documents and pleadings to be shared using blockchain. So this is where the technology came in. So this authenticates that the documents have been submitted by the parties and the pleadings have been submitted by the parties. And blockchain was used as a verification mechanism. And there was also an interaction with what they termed an arbitration library, which included the code of smart contracts, which can automatically interact with the arbitrator. And smart contracts effectively are contracts written in code, which are meant to be self-executing. The various permutations for the contract are written into the code, and they're meant to be able to self-execute. And the arbitration library includes this code for the smart contracts, and therefore can automatically interact with the arbitrator. So we can see this is then beginning to move into a braver, newer world. There is another institution that has come up with an entirely different way of resolving disputes, particularly for smart contracts. And this is an institution that Stephanie mentioned called Celeros. And I think the way to think about Celeros is best to think of it as a decision protocol for a jury-based online dispute resolution system. So this begins to look very, very different from what we may understand arbitration to be. Every step of the arbitral process is fully automated. It builds on these new ideas such as crowdsourcing, blockchain, and game theory to develop a system of justice that aims to produce decisions correctly, securely, and cheaply. So it even goes beyond, it certainly goes beyond the old way of arbitrating, where it tries to actually, using crowdsourcing and game theory to develop what it thinks might be a better system of justice. So let me explain this perhaps in a little bit more detail. So as I said, it's a game theory-based system of justice. And the way this works is that it encourages the jurors who are crowdsourced, the jurors to come to the right decision. And it does this by rewarding jurors when they arrive at a correct result, and disincentivizing jurors when they arrive at an incorrect result. So a juror that arrives at the correct result, and the correct result here is the one that the majority of jurors vote for, will be rewarded in terms of coins. And I believe they actually do make payment in terms by cryptocurrency to their jurors. But the disincentive comes if the juror decides wrongly, then they are deducted, their coins are deducted. So you can see this is a very different way, a different system. But the idea here is that based on the game theory that this is what will encourage and incentivize jurors who are crowdsourced to come up with the correct result. So how does it work in practice? So let's assume that Mr. A hires Ms. B from an online platform to carry out some work, but is not happy with the work done. And those possibly could be small claims. So let's assume in this case it was a small claim and it's only a few $100s. So it made no sense to try and take this through the traditional court system. If this involved a smart contract, then the dispute could be resolved through what the Cleros calls the Cleros court. And A initiates this by tapping a button and sending the dispute to Cleros with a description of the claim. And then Cleros automatically connects A's claim to various potential jurors. So this is the crowdsourcing aspect of it. Who, if they are accepted by the system, are then given the evidence and specific period to submit their decision. And the jurors are selected randomly for a pool and will not know who the other jurors are. So this again is the game theory aspect of the system. And then the jurors then submit their decisions, and the outcome of the majority is made known to A. And if A wins, the smart contract transfers money automatically. So it's all meant to operate automatically. And the jurors are rewarded or penalized for their work, and the case is closed. So we can see it's a very different way of dealing with it. I think questions could be asked as to whether this is actually arbitration. Certainly whether, are these arbitrations under the New York Convention? First of all, you have the question of, at the moment, there is a need for a writing requirement under the New York Convention. And if the arbitration clause, for example, in the smart contract is in code, there is a question as to whether this is in writing. Because in code, it may not be writing as we understand it now, but the law does evolve. And there was a amendment to the ancestral model law, which recognized that writing could be an electronic form. So I don't see no reason why, as things develop, that perhaps code can be accepted as writing in time. But perhaps more fundamentally with something like Cleros is the question is, is this an arbitral award? Because arbitral awards are made by arbitrators appointed for each case. And the question is whether these jurors are arbitrators. They are unknown jurors who do not know each other. As I pointed out, the way it works is that for the game theory aspect of this to work, they are anonymous to each other as well. And is this an arbitration award? Although the New York Convention does recognize awards by permanent arbitral bodies, but that still begs the question as to whether Cleros is a permanent arbitral body. But perhaps this may not matter because this is meant to deal in the world of smart contracts with us, which are self-executing, and one may not actually need recourse to the New York Convention for any execution. Enforcement of the award. I think before I leave this point, I should just mention there's been other work done in this field. And this has been by the UK Jurisdiction Task Force. So this is a jurisdiction task force set up by the Ministry of Justice in the UK to look at two issues. One was they looked at the question of cryptocurrencies and smart contracts. And to determine whether or not these, being purely virtual, you can actually be deemed property. And perhaps this may surprise those of you who are watching who do invest in cryptocurrency, is that there is a legal question as to actually whether there is any property in cryptocurrency, although you may be assured to know that the UK Jurisdiction Task Force did decide in the statement on crypto assets and smart contracts that these can constitute property. And I'll mention later a Singapore case which came to a similar decision. But they also followed that up with development of some digital dispute resolution rules. This comes back to perhaps more familiar ground. It is arbitration as we are more familiar with it. It bears the hallmarks of arbitration as we're more familiar with it, except that it tries to make accommodation for the digital realm. So, for example, the rules have a extremely broad applicability to digital assets disputes, coupled with maximum flexibility. The rules may be incorporated into a contract digital asset or digital asset system, so it could cover things like smart contracts and codes, etc. There is accommodation for an automatic dispute resolution process, because this is what is intrinsic in a smart contract, that they're meant to be self-executing, and these rules are meant to coexist along with the fact that the aspects of the dispute resolution process may be self-executing. With no surprise, there's a preference for electronic means of communication. I think many of us have no difficulty with that. But we do have arbitrators. So comforting to those of us who do sit as arbitrators, that we're not made extinct. There are arbitrators appointed, in this case, by the Society for Computers and Law. It does allow for direct enforcement by the tribunal, which again comes back to the point of smart contracts, where you can have self-execution. And it does provide, Stephanie mentioned the question of seat, so it does provide for a default seat, in this case the default seat being England and Wales. And it's stated this is where courts are gathering considerable early experience in digital asset disputes. So no doubt there is a move here to drive disputes towards the English jurisdiction, but it is a very encouraging move to see that a jurisdiction like England, which is sometimes, particularly the common law world, associated with traditional justice, it is the fountain of the common law. But we are seeing that even in England, they are grappling with how to deal with these new technologies, these new types of assets, these new metaverses, and how dispute resolution can evolve to effectively deal with the sort of disputes that we will see. So let me stop here on the various different forms of dispute resolution that we've been seeing being developed for the new technological order.
Thank you, Stephen. That was really helpful. We have a couple of questions. We do have a choice as to whether we wait or just take a stab at it and try to address some of the ongoing queries here. I think the first question from the audience was, apart from the commercial aspect, do you see any practical applications of NFTs for lawyers? And then alternatively, the other question I think is along the same line, but about the reverse topic of the same issue. And the question is, excluding arbitration, how do you think the metaverse can transform companies, big or small? I could start by addressing the most recent question about the transformation of the companies, big or small, by the metaverse. I think we are all in agreement that the companies are still trying to charter the road and follow the evolution of the technologies. But we've already seen, and earlier in our session, addressed some of the developments utilized by big manufacturers of designer goods and accessories. They are actually availing this metaverse platform as a way to provide an expression of their designer goods that are not physical in existence, but actually virtual and are traceable and can be minted online. And so that could create a whole another universe no pun intended, but a whole other universe of being able to transact and create an expression as well as economic means of gathering profits. And so in that sense, we tend to think that there could be a new creative industry that is being created by this new forum called Metaverse. And then it can create all different areas of dispute pertaining to, copyrights, trademarks, product liability issues, and perhaps even tort for the users of Metaverse if they interact with each other in a way that is not legal or even tortious. Then does vicarious liability or some form of tortious liability automatically apply to that particular user's avatar? And it just creates a lot of different areas for interest. I'll pause here, but I'd be curious to hear what Stephanie and then Stephen may want to say on these topics.
Thanks, Myung-Won. I fully agree. I think the metaverse, if I also take the second question first, I think it opens a lot of new options for companies. You mentioned exactly the selling of virtual designer goods, but you could also imagine that companies, would offer their goods or services on the metaverse, but then still provide the goods or services in the real world. So for example, if you have a virtual shopping mall, and then you could enter a shopping center and look at the clothes, and if you order them, they are being sent to you in the real world. So I guess it not only opens sort of the new universe, but also a new marketability of the real world goods and real world services. Absolutely. So yeah, it's going to be interesting to see what the next years will look like in this regard.
Let me pick up on the question about the NFTs, because we've actually, while we were talking, another question has come up about the legality of using images of personalities and celebrities, NFTs, and the images otherwise IP of the photographer, and will a license be needed? I think NFTs actually would be a great field for intellectual property lawyers, because they just provide a whole new field for intellectual property breach and everything else. I mean, while they exist in the digital universe, they're still subject to the same laws, intellectual property laws. And I think there will be a great scope for people who want to issue NFTs to ensure that they obtain the right advice as to whether there's been any breach of intellectual property rights, copyright, etc., in issuing these NFTs. And no doubt there will be breaches. I think earlier in the presentation, as mentioned, there already has been claims brought for breaches of intellectual property rights by NFTs. And so there will be a great scope for claims for breach of IP rights for NFTs. So that's probably one of the easier digital assets for us to translate into old world concepts, compared to perhaps the metaverse and other braver, newer worlds of the digital world.
Thank you, indeed. We now will move forward on our topic, but it's going to be relevant in terms of understanding what are some of the practical takeaways or concerns or precautionary measures that we may need to take. So with that, may I come back to you again, Stephen, on the issue of whether arbitration is a well-suited form of alternative dispute resolution to address the disputes in this evolving area of technology?
It may sound like a self-interested answer, since I primarily am an arbitration lawyer, to say the answer is yes. But I think I've also demonstrated that by what I discussed earlier about the different arbitration rules that have come up with this. One of the great aspects of arbitration is its flexibility, that arbitration is a very flexible form. And I think, in fact, many of the different disputes that we have now can be accommodated within the arbitration rules that we have. The UNCITRAL arbitration rules, or even the ICC rules or other institutional rules, they are broad enough and flexible enough to incorporate many of these aspects that we were seeing. But we've also seen, as I mentioned earlier, that there has been a move to evolve arbitration to specifically incorporate aspects which are unique to this digital universe. And I use the example of the digital dispute resolution rules from the UK jurisdiction task force. And these, we can see, don't fundamentally change the structure of arbitration. The structure is preserved, but they just take into consideration certain aspects about the smart contracts, for example, of direct enforcement become a possibility, of automatic dispute resolution processes being built into that to be given effect to. So arbitration in that sense then becomes very, it is flexible enough to incorporate all of these platforms. The other thing I should mention for this answer is that arbitration is also can be a very broad concept. It can possibly, I raised the question as to whether the Cleros system is arbitration, but I don't think I have a definitive answer for that. And it may be that arbitration could well be broad enough to encompass something like that. So in its flexibility, in its ability to evolve and incorporate these aspects, particular aspects of the digital realm, and I think arbitration is definitely well suited. Although I have to add also, it will have its competition, because we also see that courts are waking up to the idea that they have to develop as well to accommodate these disputes. And the courts would also be, I'm sure, gearing up, as we have seen with the UK Jurisdiction Task Force, coming to grips with the idea of this. And I mentioned earlier a Singapore court judgment, and maybe I'll just mention that here as very quickly as an example of how the courts are dealing with this. So this is quite an interesting case where an American owner of Bitcoin and Ethereum found that his Bitcoin had been stolen, but he was able to trace these codes, which is what Bitcoin and Ethereum are, to cryptocurrency exchanges in Singapore. So he brought a case in the Singapore High Court for a freezing injunction to freeze these bits of code, with these cryptocurrency exchanges. He had two primary issues which the court had to deal with. First of all, the question was there any property right to be protected? Because all these were ultimately were lines of code. Although the court ultimately did decide that cryptocurrency satisfied the definition of a property right, following classical English common law definition of what property rights were. And the other difficulty that he had was he was able to trace these bits of code to these cryptocurrency exchanges, but he was not able, he still doesn't know who the entity was that had stolen it. And the question also arose as to whether the court could grant an injunction against unknown persons. They could freeze the cryptocurrency assets, but they also wanted to freeze the assets against the perpetrator. And the court actually, again, applying common law principles, found that they would extend, the jurisdiction of the court would extend to that. So we've seen here also courts adapting and dealing with these new concepts that we're dealing with. So while I say that arbitration is definitely suitable, it will have its competition cut out for it, but competition is good because then it drives all platforms to up their game.
Thanks, Stephen. As you mentioned, flexibility is really the key word on why me too. I believe that that arbitration is well suited to resolve disputes in these evolving technologies. let me mention four points on the overall theme of flexibility. One is the arbitrator appointments. We know that in arbitration, parties can usually select their own arbitrators. Well, they cannot do so in state court litigation. So that allows parties to appoint persons that are knowledgeable in the field that is relevant in the case at hand. Or what we may see in the future is that there are specialized institutions for these modern technology disputes that have a panel of knowledgeable arbitrators from which you could draw your arbitrator candidates. And then of course, we have the flexibility in the proceedings, and what is most important in this regard is that the proceedings are normally in the hands of the parties, so the parties can agree on how to shape their proceedings. This is another important characteristic that makes arbitration well suited for these disputes. The parties, of course, could agree, and I would say this should be possible even under many of the current rules to hold the entire arbitration in the metaverse. Or they could agree that some certain forms of evidence should be admitted, because arbitration rules are very flexible in this regard, and they may not be admitted in state court litigation. Let's if we have a look at, for example, at codes, how do state court even read those codes, or how can you submit a code to a state court litigation? Finally, the parties could agree to some sort of automatic resolution process, as we have seen, although we are not sure, Stephen mentioned, whether this still qualifies as arbitration. The third point is the electronic means of communication. Now, in fact, it would be quite strange to conduct a dispute that has arisen in the metaverse in a paper-based litigation with an in-person hearing where the real person behind the avatars need to appear and conduct the disputes, and they would probably need to fly in from very remote locations, because in the metaverse, persons from very remote locations can easily interact with each other. And the last point is the enforcement of awards. Arbitral awards can be quite easily enforced because of the New York Convention, to which around 160 states have acceded to. Again, in the metaverse, you may encounter avatars belonging to people from very remote locations. And if you are in dispute with these persons, or with a metaverse platform as such that may be seated in Panama or whatever, it's for sure an asset to have an award that can be enforced in that location. Thank you.
Thank you. Well, that has been really helpful and informative. And in order to conclude our session for now, I know we do have a lot of other things to discuss, but this is a good start. For now, for our audience, I was just wondering whether we could share a couple of takeaways, practical takeaways to ensure efficiency in the way they face and resolve disputes via arbitration, most likely, but in general as well. Let me start with Stephen first.
Well, the one takeaway I'd like to leave the audience with is this, which is that we are dealing with some very, very new and different concepts here. And we're also dealing with a very broad range of concepts. And perhaps issues like cryptocurrency, while again, part of the brave new world, it's become much more accepted, and we've seen that the law, at least I've mentioned in the common law, has been able to come to grips with this. This is property, etc. But as you start moving down this track towards perhaps smart contracts and other aspects in the metaverse, which I have even much less of a grasp with, a concrete grasp with, if it is possible to have a concrete grasp of the metaverse, would be then that if you are looking at a dispute resolution mechanism, then you really need to understand what sort of which part of the digital realm are you dealing with to begin with, and what special aspects that this particular asset brings, which needs special treatment, like smart contracts, etc. And then you need to find the appropriate mechanism that would deal with that. So I think it would be it wouldn't be wise for me to just recommend that you have a particular there's one form of arbitration and say this is going to cover everything you're going to need. I don't think that this is the case for now for the various very diverse forms of rights that we're dealing with here. So my one takeaway is you really need to understand what you have to deal with, and then look for the appropriate dispute resolution mechanism. But the point I guess, if I'm going to make a second point, the second point I would make is that these do exist, as I pointed out, that there are institutions and entities that are trying to provide the dispute resolution mechanism that might suit that need.
Indeed. Stephanie.
Thanks, Stephen. I fully concur with you. I would say make sure that you select the dispute resolution mechanism wisely, that is able to efficiently handle your dispute. We've seen that there are, especially in the arbitration field, that there are various institutions, common arbitration institutions that allow for that flexibility, but also specialized arbitration institutions. And what I would add to the list is not only choose your dispute resolution mechanism wisely, but also choose your governing law, the substantive law, wisely. Of course, I know this falls a bit outside of the arbitration clause, but still make sure to choose a law that is friendly enough to digital assets and that has a state-of-the-art or modern legislation that enables you to have the rights you think you have under these digital assets. Thank you.
Understood. I agree with both of you as well. I mean, in terms of, say, timeline prior to the dispute, what I would recommend the audience or the client to do is to ensure that there's precise wording in dealing with both present and the future technological developments by way of putting a precise reservation of rights clause. We know we referred to that California Federal Court case previously in our session, where the scope of the reserved rights became a hotly contested issue because the technology itself was not in existence at the time of the contract. But we are in a better place in order to provide for that type of prospective and reasonably foreseeable technological developments. Seat of arbitration, governing law of the contract would be quite critical in terms of determining how the procedural rules, including the enforcement, will be adjudicated. And so that quote-unquote boilerplate clause may play a key role. So ensure to take a look at it one extra time before you sign the contract. After the dispute arises, now that becomes slightly more tricky, but technology issues are still not so familiar to the mass audience in arbitration, but ensure to secure a competent tribunal who would ask precise and apt questions and who would actually have the capacity to grasp and understand the background issues as well. And then finally, it might be helpful, and I think Stephen and Stephanie, you both pointed out quite helpfully that there are institutional evolutions in place right now in terms of arbitration rules. There are already a system in which bifurcation of the issues where technology issues may be carved out to be resolved earlier in order to expedite or facilitate the overall general resolution of the dispute. And so utilizing that type of mediation, carve out, or bifurcation settlement procedure might also be of use to our audience and clients as well. Well, I'll stop here. I mean, it has been really interesting for me personally, and very educational as well. And I hope that it was also helpful for our audience too. There have been a few questions, but what we can do is avail our bio and contact info as well as a link to our audience, so that if they have any questions, they can always come back and ask in turn. And the link, the recorded link of our webinar will also be available on YouTube, and then maybe perhaps in the future on the Metaverse world. But for now, that's where we are. Any other last bit comments or questions from Stephen or Stephanie?
Just for me to thank you, Myung-An, Jung & Yang, and Legal 500 for putting this on and having me to be part of this. Thank you very much.
Thank you.
Thank you. I also thank you very much for having me. It was a pleasure to do this.
Likewise. Thank you. I think that concludes our session today. Legal 500, Mr. Cohen, if you have any questions, we can also answer, but would we be excused for now? Thank you for availing your forum.
Thank you very much, Myung-An. Thank you to Stephanie and Stephen. It was remarkably interesting, very useful indeed. Huge thank you to Yun & Yang as well, and to our audience. We hope to see you at another webinar shortly. As Myung-An said, the link will be uploaded on the Legal 500 YouTube channel indeed. And we will see you soon. Goodbye, everyone.